We existed before Zionist colonial invasion. We exist now even among the rubble of humanity's remains. We will exist when Zionism is dismantled bit by every racist colonial bit.
That was Palestinian-American international lawyer Noura Edikat addressing the 2023 Palestine Literature Festival. Welcome to Exploring Nakba as a legal concept and its implications for Palestinian liberation. I'm Elena Lugo.
I'm Raquel Abifadel.
I'm Safia Sangster.
And I'm Colonnello.
We're master's students at the Geneva Graduate Institute, and we have produced this podcast as part of our course, Human Rights and Humanitarianism Through the Concepts.
Imagine losing your home, your land, and your community overnight. For over 700,000 Palestinians in 1948, this became a devastating reality. The mid-20th century saw the aftermath of World War II, the collapse of colonial empires, and rising nationalist movements. In Palestine, as British rule ended, tensions grew between the indigenous Arab population and the Zionist movement. Zionism, a political ideology advocating for a Jewish homeland, gained momentum in the late 19th century, especially after the Holocaust and European anti-Semitism. Zionist militias launched a campaign of displacement and violence to establish Israel on Palestinian land.
The Nakba means catastrophe in Arabic, and marked this mass expulsion of Palestinians in 1948 and the start of their ongoing struggle for self-determination. It fragmented Palestinian society, led to illegal land settlements, and triggered decades of displacement, occupation, and resistance. But it was not just a historical event. The Nakba raises key legal and human rights questions that remain relevant today. The past year's events in Gaza have renewed attention to the 76-year-long Palestinian struggle for self-determination. The violence has underscored the complex layers of Israeli occupation and sparked intensified debates on how to address the ongoing injustice faced by Palestinians.
In May 2024, Palestinian human rights lawyer and legal scholar Raquel Abifadel published a paper in the Columbia Law Review titled Toward Nakba as a Legal Concept. He writes, Palestine is best understood through the prism of Nakba, which may fulfill the legal definition of occupation, apartheid, and genocide at various points, while still transcending their confines. The terms we possess have failed to capture the reality of Palestine.
In this episode, we take Akbaria's argument and test it with other actors from international politics and academia, examining Nakba not just as a catastrophic event, but as an avenue to address ongoing legal and socio-historical challenges that Palestine faces. We also address the censorship of the article itself and the barriers facing those who counter dominant narratives and structure regarding Palestinian history, legal position, and struggle for self-determination and justice.
To understand how Palestine operates within the international legal system and how the concept of Nakba could address systemic gaps, we spoke with Ambassador Ibrahim Qureshi, who leads the permanent observer mission of the State of Palestine to the United Nations. He reflected on the limitations and opportunities within existing legal frameworks.
The IHL and the Geneva Convention, especially the fourth one, which is applicable for us as people under the occupation and the protection of civilians. A lot of those provisions are perfect. There is no need to add. But the problem of the IHL, the empowerment, the respect, Israel is not respecting. So how we are going to enforce Israel to respect? By not asking the state to send for us F-16 or bombs. No. By asking the third states party, the contracting parties, to implement the Geneva Convention's provisions, some of them calling, if there is one of the contracting parties not respecting, they should reconsider their diplomatic relations, to consider the trade agreements, to put some kind of sanctions by transfer, for example, weapons. The cooperation with settlements and settlers as also grave violation, which is according to the Rome Statutes.
So the ambassador is referring to the meeting of the high contracting parties, a meeting that will be convened next by the Swiss in Geneva, March 2025, and really aims to bring together every state in the world to ensure respect for the four Geneva Conventions 1949, which protects civilians, including those under occupation, which is, of course, the case for Palestine. And crucially, the article reads, the high contracting parties undertake to respect and to ensure respect for the present convention in all circumstances. So it refers to this obligation of third states, i.e. every other state in the world, to ensure respect for the convention. And the controversy really lies in that some states don't consider that they have to do this, and the limit of the current legal framework and whether it's fit for Palestinians. The ambassador is also speaking to the importance of Articles 146 and 147 of the conventions, which create a universal criminal jurisdiction for certain war crimes and puts a responsibility on states to arrest war criminals. I guess although the ambassador hasn't gone as far as outlining the need for a new legal concept, he has highlighted a limit of the international framework. Do the legal concepts that exist suffice? Or is this political negotiation between which of the current war crimes apply to the Palestinian condition best, creating legal loopholes for Israel's breach of international law? To draw this point out further, we asked the ambassador his views on the multiplicity of crises inflicted on Palestine today.
But this one is an apartheid. And some, they don't accept the idea of apartheid. But this is the apartheid. When you will find some roads only for the Israelis and for the Palestinians. The laws for Israelis, laws for the Palestinians. And every day in the Knesset, they are adopting stupid laws, discriminatory major. Like now, some of the Europeans, they don't accept the idea of genocide. The ICJ, they issued the 3 orders, what they call it, preventive measures, because there is a plausible genocide acts. Go and read the Convention of Genocide of 1947. You will find that this is a genocide.
The frustration that Palestine faces in the international legal system is palpable in the ambassador's interview. And even with attempts, agile or creative political maneuvering, this resistance from powerful states to bring justice to the totality of the Palestinian condition that both Ambassador Qureshi and Rabia Agbaria refer to, so displacement, genocide, and apartheid, is overwhelming. So to understand how centralizing the Nakba could support this and to also broaden our lens from the sphere of international law, we spoke to Atwa Jaba, a PhD researcher in international history and politics at the Geneva Graduate Institute. He discussed with us the socio-historical implications of Nakba and how memories of 1948 shape modern Palestinian identity and resistance practices.
Would you say that your research engages Nakba as a concept as well as the event? And if yes, how?
Quite directly, I would say, for 2 reasons. One, because conceptually, in my research, as many other scholars in the field of Palestine studies, I deal with Nakba as an ongoing process rather than an event that happened and stopped in the history of Palestine and the Palestinians, which encompasses a huge amount of historical injustices against the Palestinians, one of them being forced displacement, of course, which is maybe the focus of my work, but also the denial of return. Second point is that specifically in the area where I do my research, the Jordan Valley in 1967 had been, at the time, for almost 2 decades, quote-unquote, reservoir for the Nakba refugees. More than 100,000 of them lived and to a certain degree prospered in the Jordan Valley, having been forced from their homes in 1948. As my research unfolded, it became more and more evident that the centrality of the Israeli project towards that area in 1967, which was one of 2 areas where ethnic cleansing took place, because they were full of Nakba refugees, they have been forced again into another perpetual cycle of displacement and denial of return, going back to the camps, to almost the same material conditions in which they found themselves in 1948.
So what role do oral history, memory, and political consciousness have in respect to Nakba and the liberation of Palestine?
Oral history and oral testimonies and popular/collective memory has been tied very strongly to addressing the Nakba as a historical event, but also as a concept for so many reasons. But the main reason of those is that while this process of Nakba has been ongoing, there has also been an ongoing process of other forms of erasure. So you had the erasure of the Palestinian towns and villages and the displacement of people, of Palestinians, but also there has been an equally strong process of erasing the memory of the Nakba. And this has so many examples, such as the plundering of Palestinian archives, personal collections, writings, even films and audiovisual materials, or also photographs.
You have talked about the importance of the oral aspect to, in some ways, reconstruct a history of the Palestinian people as a displaced people throughout the process of Nakba. I would love to hear some more about the political aspect.
If you look at the historiography of Palestine and the Palestinians, you would often stumble upon the use of plural when you talk about Palestinian identity. So it would be identities. You had different perceptions of what is a shared Palestinian identity at the time. And this is from my own reading of this history. And then comes the Nakba. And I think this is one of the few points where the plural kind of evaporates. Of course, you had different perceptions of the experience of the Nakba, but the Nakba as a political event is perhaps one point where all of these identities crystallize into one shared experience. Of course, of misery, of displacement, of the unknown. The Palestinians suddenly became a symbol of refugeehood, and for a period of more than a decade, become a mere symbol of humanitarian aid receipt. And then this one identity started again to become plural, but you still have the Nakba as the one shared experience where all of these political identities meet because they have collectively lost and they had been collectively working towards rebuilding what has been lost or rather stolen from them.
Thank you so much, Atwa. Do you have any final words?
If we follow the logic of Rabia to acknowledge the Nakba as a legal concept, that would, for example, give weight to the Nakba as, scholarly speaking at least, it will give it weight as a point of entry, because when you acknowledge the Nakba, then you acknowledge all the atrocities that happened with the Nakba. There is potential, but for that potential to materialize, there needs to be more and more acknowledgement of the atrocities that are encapsulated within the Nakba, because until today, Palestinians are trying to achieve what has been even enshrined in international law, the right of return, etc. There is still more to be done, but there is always hope that focusing on the Nakba would help us move towards a more just future for the Palestinians.
Iqbari's article, which inspired this podcast, argues for recognizing the Nakba as a legal concept alongside other crimes against humanity. Yet, its journey to publication underscores the resistance such ideas face. Initially removed by the journal's board of directors under the pretext of procedural concerns, the decision coincided with mounting opposition to the article's content. This sparked public outrage and widespread media coverage from outlets like The Guardian and The New York Times. The article's eventual reinstatement, after significant pressure from the editorial staff and public, highlighted the censorship at play and the power of collective advocacy. As Mr. Jaber stated during his interview,
despite the censorship, the fact that you are sitting with me today to discuss the whole question of Palestine within 45 minutes, departing from the Nakba, means that despite all of these attempts to silence and erase, the memory is still there. Due to the fact that since the Nakba, there has been an immense body of work that not only documented, but also analyzed all of these experiences until today.
As we conclude, we return to the questions that have shaped this podcast. How does recognizing Nakba within the framework of international law challenge dominant narratives and offer avenues for accountability? And perhaps most importantly, how can the Nakba, as both a historical event and legal concept, illuminate paths to justice for Palestinians? The insights shared by Ambassador Qureshi and Atwa Jaber underline the centrality of the Nakba in understanding Palestinian history, identity, and resistance.
From international legal frameworks to collective memory, the Nakba is not merely a historical moment, but an enduring process shaping the lives and struggles today.
Thank you for listening to our episode on exploring Nakba as a dual concept and its further implications for the realization of Palestinian liberation.